This is Michael Cowen, and welcome to Trial Lawyer Nation.
You've got to have the right case, because if you take it up and it's the wrong case, then you can make some really bad law that's going to affect a lot of plaintiffs.
There's always an answer. The joy is in finding it.
One of the reasons that I love being a lawyer is this exact process.
The way we live our life has nothing to do with the presentation sequence at trial.
As trial lawyers, we pick up and move on and keep going.
You're losing or gaining 1 out of every 10 jurors, which can really make a huge difference in the ultimate result of the case.
Whatever you think about, you create.
Learn all you can and never stop. And then have the guts to try case after case after case.
Welcome to the award-winning podcast Trial Lawyer Nation, your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
Today on Trial Lawyer Nation, I'm here with my partner, Sonia Rodriguez, and we're going to try not to just bitch and whine. We're going to talk about the surviving and trying to thrive when this darn pandemic keeps coming back, keeps taking trial dates away from us, and makes us having to find ways other than just trial pressure to get cases settled, because they keep canceling trials in a lot of jurisdictions. Sonia, how are you doing today?
I'm great, Michael. It's good to see you.
It's good to see you too. And for those of you listening, if I sound a little whiny or bitter, I was supposed to be in trial in Charlotte, North Carolina on Monday. We're recording this on a Thursday. And unfortunately, yesterday morning, we got an email from the court saying that trial's canceled because of COVID. And, I respect the courts. They need to do, they're making hard decisions. They need to do what they have to do. But it is disappointing that, you do all the work to get ready. We had our hotels booked. We had practiced. We had all our witnesses prepped, all our experts ready to go. And then, just a few days before trial, they tell us we don't get to go. So how do you handle that, Sonia? That's happened to you too. That's happened to you too.
It has. And unfortunately, in the last, year and a half, it's the new normal of being ready for trial and getting ready for trial and, having the rug pulled out from under you. And I think all the time about how blessed we are to be able to have the experts lined up, have everybody ready to go, have everybody paid in advance to get them here for trial. And it really is a blessing to be able to say, we will live to fight another day if we are continued or if we must be continued. But I think all the time about these lawyers out there who, have invested so much money and time and energy and effort into getting ready to go to trial, lined up all the experts, got the hotel rooms booked, and then have that rug pulled out from under them. And then they've got to recalibrate and figure out how the heck they're going to invest that money again to get ready for a second trial setting.
Yeah, it's tough. And a lot of the money, an expert's going to charge you so much money to get up and ready each time. And so it really does get to the point where, depending on the size of the case, now on a death case, a spinal cord injury case, you can do that. But a lot of cases, if you have to pay experts to gear up 2, 3, 4 times, the costs will diminish your client's recovery to the point that even if you win, it's not really a win for your client.
And I think that has a lot to do too with the types of experts you hire. The real professionals know that this line of work is, sometimes got shaky ground when it comes to trial settings, and they will reset and reschedule without charging you extra, or, it's part of the cost of doing business. But there are some experts who, aren't as forgiving. And so it's tough. And so I think that goes back to, knowing who you're working with early on in the case and making sure you've got people who are professionals and know what they're doing and what this investment of time and energy involves on their end, which means being ready to be flexible if it has to.
Absolutely. Because, at the end of the day, we want to make money. We want to do well and get big verdicts, but it's really about the client. If we don't get the client a better recovery from trial than they would have had they settled in their pocket, we're not just talking about the verdict, but what the client ends up with after everything else gets paid, we've not done them a service.
Right. I think the unfortunate thing that this pandemic has now created is a gigantic wrench in your damage model, in your settlement values on cases. because whereas before you could evaluate a case and the potential recovery to the client based on a relatively firm trial setting. We all know that, even in regular times, non-pandemic times, the certainty of a trial date was never really that certain. But now the prospect of having to prepare multiple times for the trial setting is going to multiply the cost. And that's thrown a wrench in how you evaluate what the client is going to get in their pocket. And it really complicates things from the plaintiff's perspective.
Absolutely. I mean, to some extent, the insurance companies are having to pay multiple times too, but they also are earning money on the investments for the money that they aren't paying us. Right. And then they also have the hope that, they just keep it tough and expensive. We'll settle for discount, which I know at our firm we're not doing, but it is a temptation for people, and I understand it too. I mean, if you can never get to trial and they won't pay you what's fair, I mean, some clients that can't afford to wait. That's the other problem.
Right. And I think insurance companies have a different evaluation. They've got a pot of money that they're using to pay for attorney costs, and then they've got a pot of money that they've got to pay for the value of the case. And so, it's a lot more painful for the plaintiff's bar than it is for the defense bar, insurance bar, as far as I can see it.
Absolutely. Yeah, because the insurance companies are paying out so much less in settlements on big cases because they're just not going. They can afford to pay more in defense costs.
Right. And I think it's easy for us to say, and I mean, I'm blessed every day to think through the fact that, we don't have to settle our cases cheap. We can hold firm. We can continue pushing our cases. And, but frankly, there are a lot of lawyers out there probably listening to this podcast who have to think twice about the settlement offers based on the realities of not getting a trial date in the next, 9 months or so.
Well, honestly, 10 years ago, I would have to be thinking a lot differently. I mean, it's been a lot of, the fact that we've deferred gratification and invested money instead of spending it on fun things sometimes so we could have that footing to be able to hold out when times are tough.
So one of the good things, though, that I think we should talk about is during times like this, what can people do to still maximize the value of their cases during a pandemic? Like, what can we as the plaintiff's bar continue to do to still hold insurance companies' feet to the fire and not settle cheap and continue to push our cases for what they're worth and maximizing the value of every single case? And, I have to confess that for some inspiration during these tough times, I've had to go back and reread some old books on my bookshelf and 100-year-old strategy books. And so one of the books I pulled off the bookshelf recently was The Art of War, Sun Tzu's The Art of War. And, when I read it the first time, it immediately gave me a lot of guidance and inspiration for how to work up my cases, how to settle my cases for the maximum value. But going back and revisiting it now during a pandemic, I feel the same way. Renewed energy on how you can continue to work up your cases and be creative in developing your cases, even during a pandemic. If you can't get a trial setting, in most jurisdictions, you could still get hearings on motions to compel. You can still get hearings on motions for summary judgment. You can still push for discovery. And so, what types of creative things can we do as lawyers, even though we don't have a trial setting? Going back to couple 100-year-old book on war strategies has kind of been an inspiration for me.
And yeah, I'm actually looking forward to hearing this because I've, just the way we've set up the firm, I tend to only work on the ones that are getting ready for trial or that might go to trial on it when, as far as the deep dive day-to-day working. And then you've had some really good success. And I personally thank you for it because it's helped us this year on getting good money on cases, even in jurisdictions where they already told us you're not going to trial on any case in the next, 8 to 10 months.
Well, the irony, Michael, is that I've been practicing law for almost 25 years now, and I've never made more money in 1 year period than I have during this pandemic.
Wow.
so what the heck is going on?
Yeah.
I don't know what is going on, except that I have kind of gone back to the well when it comes to rereading The Art of War and kind of using that as a touchstone for developing my cases and working up my cases and keeping absolute pressure on the defense when it comes to working up my cases.
So what are some of the things you've learned from The Art of War that have been applicable to your practice?
So the primary theme that I keep, at the forefront of my negotiation strategy and my case preparation is that it's in chapter 3 of The Art of War. And Sun Tzu says that supreme excellence consists in breaking the enemy's resistance without fighting. And so if you use the analogy of fighting as a trial, so supreme excellence consists of breaking the enemy's resistance without a trial. It's highly relevant today, where we don't have trials at our disposal.
Right.
So what do you do to break the enemy's resistance when you don't have the luxury of trial? And so Sun Tzu's The Art of War has a philosophy that's very similar to modern day war strategy, which is if you want peace, prepare for war. And so what I'm doing in all of my cases right now, despite the pandemic, is pushing and preparing as if I am going to trial at a moment's notice. And that means hiring all the experts I need to hire, preparing all the experts that we need to hire, paying for the exhibits that we need to prepare for, and literally following the templates that are laid out in The Art of War as if I'm preparing for trial. And so some of them are like the first chapter in The Art of War is laying plans. So when you're laying plans for a war, part of it is strategizing your strengths and your weaknesses and investing your money where you need to. And a huge part of getting ready for war is knowing what your strengths and weaknesses are. And I don't want our listeners to think that somehow we're blessed by having all the perfect cases.
I wish.
And that not one of our clients has pre-existing medical conditions that they didn't tell us about, or that there isn't some YouTube video or Facebook video of them doing something ridiculous when they shouldn't have. Because if you're any type of a trial lawyer, you've got those cases. Everybody has those cases. And the reality is the best lawyers still have those cases, but they know those issues exist and they can still strategize and evaluate their cases based on knowing those weaknesses. So, and that's another big chapter in The Art of War, which is knowing your strengths and knowing your weaknesses.
So how do we find out our weaknesses in our cases so that we can find a strategy to overcome them?
So for some people, I think weak points and strong can be assessed by intuition and just listening to your gut. You know when you walked into a meeting with a client and there's just something that doesn't sound right. It's intuitive and you kind of, I think more often than not, as lawyers, we want to kind of ignore that and say, well, I don't want to be judgmental. Maybe the client is having a bad day. Maybe they're not very sophisticated, so they misspoke. I think as lawyers, we need to listen to our intuition. If something doesn't sound right, it's probably not right. Doesn't mean that the client is lying. Doesn't mean that they're frauds. Doesn't mean they're trying to pull a sham. But it definitely is something that we as tacticians need to review and evaluate and research. Doesn't mean that we drag the client into the office and beat them over, the woodshed and make them feel bad about not knowing an answer to a question. But it's something that we need to evaluate on our own.
I agree. And if we get that feeling, the jury's probably get the feeling. The defense will definitely almost always get the feeling that there's something there, and they'll go dig more. I am finding more and more, we used to spend so much time fighting the other side's requests to get our clients past medical, and we still do. But more and more, I'm trying to get us to get everything the defense would ever wish to get, for us to get it up front. Because if our client, let's say we get our clients 5 years of medical records. We go to their health insurance company and get their claim records, so we know every doctor they've seen in the last 5 years for sure. We know every medication they've taken for the last 5 years, and we look at, are there any pain meds? Are there any anti-inflammatories? Do they have complaints back there or not? If they don't, why wouldn't we want to put those records in evidence? If the defense is saying everything's pre-existing, well, here's 5 years of medical. He didn't complain, or she didn't complain once of back pain before this crash. So how is this pre-existing? And if there is something there, they're going to get it sooner or later. Maybe if it's far enough back, we can get a strategy. But if it's something, they had back pain 10 years before, it didn't have back pain in between. Even if the defense did get it, it doesn't really hurt us that much. I think it makes the defense actually look deceptive and bad. Like, oh, you had a backache 10 years ago. Yeah, but I went 9 years without any problems until you ran into me. But if they did have some problems before and we know about them, then we can go and say, hey, look, client, here's the deal. You had some back pain before, you have back pain afterwards. What's the difference? How did it change? And before your client goes up for a depot, because a lot of times the clients, they just think they're not supposed to tell us. They think it's going to hurt their case. And when we get them to realize, look, you're going to win with the truth. If you tell, we all have some back pain every now and then. We all have a headache every now and then. Maybe you said, yeah, I had some minor back pain. I could live with it. I never missed any work. Once every 6 months I'd go to the doctor, but most of the time I didn't need to. But then once this crash happened, it put me over the edge. I couldn't work. I could barely walk. Well, now we've got a story. And now we can find the other people in your life to tell that story. But if instead our client goes in there and say, no, I didn't really have any problems before, and then they get those records, we're dead. So, just doing that intuition, but also doing that digging on our own first really makes a difference. It's a pain in the butt. You got to spend time and money digging for things that aren't, at first glance directly relevant. But I think it really can become very powerful, because the case I was supposed to try next week, he had 2 really bad wrecks 5 years before this wreck. But when we got all the medical records together, we got all his past tax records together, it was a really, really clear picture of he was really hurt for about 1.5 years. Then he got better. He had 1 or 2 flare-ups, but had gone 2 years without seeing a doctor, was working fine. We got a supervisor. We got a friend talk about how great he was doing before, and then this put him over the edge. And so now we got a great story to tell. But if our story was he was doing just fine before, that story wouldn't be credible, because they'd make him look like a liar.
I think you're right. And I think that when you are first meeting your clients and you're talking to them from day one, they need to understand that we are coming with the truth. And for us to truly come with the truth, as their lawyer, I need to know the good, the bad, and the ugly. And, even when I talk to my clients on day one about the good, the bad, and the ugly, and needing to know everything, you never get the full information. I have a firm belief that your case never looks as good as it does on the very first day that you meet your client, because after that, there's things that happen and that you learn that aren't as great. But when you meet with the client on day one, if the foundation is, we will come with the truth. And again, listening to your intuition about, any prior car wrecks, and yes, but I wasn't hurt that bad. Like, okay, some lawyers will say, well, they weren't hurt that bad. No red flags go up. Immediately, your red flags should go up.
Yeah.
And that's when you start asking about, well, who'd you see? And did you have to go to the emergency room? And it's not a situation where you're going to freak anybody out at that point. It's not, alarming, but you immediately walk out at that point and let your staff know, hey, we've got some medical records we need to order now from some general hospital on, in that jurisdiction where the crash happened. And it's better to know in advance, like you said, preparing your client for a deposition based on what we already know the truth to be is a hell of a lot easier than trying to repair testimony based on what the client's memory is, 2 or 3 years after something happened.
Or even worse, like I said, the client may have had friends, family members, someone else that works in a law office somewhere tell them, oh, don't say this, or they're gonna use it against you. And they think they're helping their case, and they're really taking it. I kind of think of the initial client meeting kind of like a first date. Everyone's trying to put on their best face. You haven't earned that trust yet. You tell them I want the good, bad, and ugly, but they're thinking, but if I tell you the ugly, you're going to reject me.
Right. And
the fact is, you do have to keep that in mind that if it's ugly enough, this might not be a case you want to put a bunch of your time and effort into. And that, I've had cases where the medical condition before looked exactly like the medical condition afterwards, and it's like, I can't do anything for you.
Right.
But you need to find that out. But you don't earn that much trust on a first visit. You have to spend time and bringing it up over and over again. But I think the big thing is, for the clients that have health insurance, and not all of them do, but just get those health insurance records and find out what doctors they've been to and get those records.
Well, the prescription records are always so telling, too.
Absolutely.
I mean, that's just an easy way to take a snapshot of what they were complaining of if they were getting medication for it. And that's just an easy, request with an authorization that doesn't have to be proved up or anything.
Yeah, no, you don't need to, and just because you have them doesn't mean if they're not relevant, you don't necessarily have to produce them.
Right.
I mean, if you had, like I said, if you find out they had back pain once 10 years before, I mean, you can't lie to the defense and say it's not there. I mean, you can say, objection, relevance, and we'll give you 5 years worth of records.
As a baby lawyer, Michael, I was terrified to get records because I believed that if I had them, I had to produce them. And that's just a misconception. It's just, naive of you to think that. But, you have to do your due diligence and know what's out there. And then you as an attorney can evaluate whether or not that's actually responsive to any requests. And you can make the proper objections that you need to not produce them if you don't have to.
But sometimes, and I want to make it clear, we're not saying you withhold damaging, relevant information.
Right.
You have to, I mean, if the day before your client was complaining of back pain, you're going to have to produce that. But, if it's 10 years before and it didn't continue, you can't lie and say it's not there, but you can put an objection saying, objection, this is overbroad. We'll give you a year or we'll give you 5 years, and then see what the judge does. So the judge makes you give 10, you give 10, and let them argue. Who cares? So trust the jury. If they want to argue, well, your back hurt once 10 years ago, therefore we couldn't have hurt you. Like, come on. That as long as you're not scared, you don't hide it and lie about it, that argument really isn't a very good argument for the defense.
Yeah.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us. You can reach DeLisi Friday by calling 210-941-1301 or send an email to delisi@cowenlaw.com. That's DELISI@cowenlaw.com. She will coordinate a time for Michael Cowen to speak with you in person or by phone to discuss the case in detail and see where we can add value in a partnership. And now, back to the show.
The other thing that I've found that is a good touchstone for evaluating a case and settlement value and negotiation strategy is remembering torts 101. Negligence is two parts, liability and damages. And sometimes I think it's easy to fall into this rut of evaluating the value of your case based on your client's damage model. I've done that before, and I think my case is worth what my damage model looks like. And that's not true. If you look at your case really carefully and you recalibrate your value plus or minus based on some liability factors, and you believe it, and you go to battle fairly evaluating both components, liability and damages, I think that it totally adds value to a case.
Yeah, liability drives damages. If the defendant did something really bad, you're more likely to get a bigger recovery. And same for damages drive liability. I mean, if you have a weak liability theory and a small injury, you're going to lose. If you have a weak liability and a death or a quadriplegic, the jury might think, yeah, that's a really bad consequence. You shouldn't have done that.
Well, it's been interesting the last, 18 months of negotiating cases and working with mediators, unfortunately by Zoom most of the time. Mediators want to talk to plaintiffs' lawyers about the low property damage or the pre-existing conditions. And to quote an old friend in Napa, I spit on that. I don't want to talk about those things. I don't want to talk about the low property damage or, the pre-existing issues. I want to talk about how this is a dirty trucking company and how they have no training protocols and how they have had crashes in multiple vehicles over the last 2 years and how the crashes are all consistently the same types of crashes because they are not training their personnel. And so what I've started asking the mediator all the time is, how come we can't talk about the things I want to talk about?
Yeah.
And the mediator has to scratch, more often than not, it's a guy, but they scratch their heads and say, well, they don't want to talk about that. And I'm like, well, I don't want to talk about the low property damage. So what are you going to do as a mediator? Wow, what's the middle ground?
Yeah, but the mediators that have worked a lot with me have learned I don't want to hear anything but their number because everything else is bullshit.
Well, at that point, that's when you stop. That's when you stop the back and forth about the nitpicky things that they perceive as problems in your case. And you say, I don't want to talk about low property damage or pre-existing issues. What you say is, if they want to talk about the low property damage and pre-existing issues, then I want to talk about their bad training history.
Also, that's why it's $1 million case, not a $2 million case.
Exactly.
But it's not a $50,000 case.
Exactly. And so it's just changing the framework of the conversation. When you remember, going back towards 101, it's two components to the case. And we forget that sometimes because we're forced by insurance companies to always assess a damage model. But we've got to remember that your damage model goes up and it goes down based on significant liability factors.
Yeah, the fact is no one really knows what a case is worth. There is no magic formula. A case, ultimately, a case is worth what a jury would do on it, but that really has a lot to do with what we decide it's worth. If we, in our heart of hearts, believe it's worth more, we can get more. And it's crazy that it gets infectious. Like, people tell you, like, that case is not worth that much money. That case is not worth that much money. And when you believe it, then the defense lawyer's like, oh, what am I missing? And they start getting scared.
I had this great mediation with an excellent mediator in South Texas last week before last. And he was shocked that I was able to get the defense energy company to pay way more than they should have on this case. And he said, what do you think? How were you able? How did you do that? And I said, I think it's because I'm going to be 50 next month. And I've decided that a case is worth what I say it's worth.
Exactly.
And I said, and if you disagree with me, let's just go try it. But the case is worth what I say it's worth. And there's a liberation that comes with just knowing that you're going to hold your ground and stand your ground. And so now that, again, is a luxury, because I know we have a lot of listeners out there who have small cases or they have cases with warts on them like we all do. And you've got to settle those cases, at all costs. The difference is, if you read The Art of War, you never, ever let your opponent know your weaknesses. And you have to come from a position of strength always. There's a chapter in the book that is called The Attack by Fire. And so you are constantly attacking by fire.
What do you mean?
And so that just means coming from a position of strength. And so if you have a really strong liability case, you're constantly taking the liability witnesses and the corporate rep depot, or you take the safety manager, or the coworkers who are also going to say that they weren't properly trained. And so you never let up on the positions of strength that you have. And so you've got to attack by fire. Even if you have other weaknesses in the case, you can't ever reveal those.
Yeah, and I think one of the things that can give settlement pressure when you don't have a trial is if you have a corporate defendant. I mean, this doesn't really work with the regular bidder cases, but when you have a corporate defendant that's going to be a repeat player and then also has, reputational capital in the marketplace, they want to be seen as a good company. The more dirt you dig on them, the bigger the fear in the company level is, I don't want all this coming out. I don't want a newspaper article after a verdict talk about how bad our company is. I don't know that I want to mandamus this judge's ruling and have a reported decision where all these facts that have come out in discovery so far get put into the record for people to read that are then going to be used against me in other cases, because people will say, hey, Sonia and Michael got all this great stuff. Let me go call them and get a copy of it, because they know that we'll share it freely. And I think that really starts putting pressure on, and it creates, you always want conflict in the other room. You want conflict between the defense lawyer, the insurance company, and the insured. And the more havoc you can create, the more that the insurance company just wants to get out of there and pay to go away. And so if you can start getting that company to tell the insurance company, I don't want to get dug into anymore. I don't want to put up another employee for deposition. I don't want to produce these documents. You get rid of this case. It puts a lot of pressure on her.
That's exactly right. And I think that one of the fun ways to strategize a case for me is to find out who my pressure point is going to be. Every case has a person who, if you make that one person squirm, is going to capitulate and say, this is too uncomfortable, get rid of it for whatever reason. And I had a case recently where an energy company hired a guy with a terrible driving record to drive a company vehicle, and they issued him a company cell phone and didn't provide him any training on how to drive safely over the road with a company vehicle and a company phone, and didn't give him any instruction on distracted training or anything like that. Well, come to find out that the guy was hired by a vice president of the company because he was a family friend. And so very quickly, the vice president of the company becomes my pressure point, right? Because does he want everybody in the company to know the favor he did for the family friend? Probably not. So you just, it takes some level of discovery. You've got to do some discovery and digging and taking some depositions to find out how'd you get hired, how'd you find out about this job, and who looked the other way when it came to the hiring processes. But every case has a person who, has that squirm factor that you can kind of put pressure on.
Yeah, and sometimes you hear it, between the lines of what the defense lawyer is telling us too. I mean, we have a case against SpaceX right now where not a rocket crash or anything, one of their employees caused a crash. And, one of the first things that phone calls I got, my name wasn't even on the pleadings, but the defense lawyer knew me. Hey, Mike, SpaceX will agree to identify the employee, but they don't like their name on lawsuits. Can you take the name off the lawsuit if we agree that the SpaceX will pay any judgment and just sue the employee? I'm like, hell no.
Yeah,
but now I know, one of the things that Elon Musk doesn't want is a judgment against SpaceX.
Right.
And so it's like, well, then, Elon, you guys got billions of dollars,
Yeah. This isn't going to hurt.
It's only going to take a few million to take care of us. So.
Right. But I think that goes back to the whole issue of your intuition and listening to what, you've got to pay attention to what people are telling you. And the reality is most of the time we don't have the luxury of being able to personally speak to our clients all the time. And that means listening to what our staff is telling us they hear, trusting your staff to warn you, and listening to your staff when they warn you that they get a bad feeling about this. A lot of people don't know this, but, I was a legal secretary before I went to law school, and my mom was a paralegal for 25 years when I was a kid. And so, I know firsthand all of the hard work that our staff does to help develop our cases. And if you're not listening to your staff and really inviting them into the deliberation of, case value and strengths and weaknesses in your case, nobody knows more about the warts in your case than the people who are talking to your clients regularly, and that's your staff.
Yeah, and if they think the client's a problem client, a jury's probably not going to like the client as much as they. And unless you have the wrong staff member, but usually if it's someone that gets along with 90% of your clients, and then there's an issue with this one, right. Again, listen to gut. I mean, it doesn't mean you dump the case, but listen to your gut on it. Going back to putting pressure, one thing I've really noticed lately is, sometimes you get that lawyer that's just really mean and nasty and raises his voice and files threatening motions. I'm realizing the more of that I get, that means I'm doing the right thing. It means that always comes from fear. Actually, even raising voice, losing temper comes from fear.
So it's funny that you say that, because going back to The Art of War in Chapter 9, the Army on the March talks about assessing strategy based on the actions of your opponent. And one of the things that Sun Tzu says is that if there is disturbance in the camp, the general's authority is weak. And he talks about how you can evaluate your opponent's strengths and weaknesses based on their actions. And I totally agree with you. that if you see a ton of aggression and frenetic activity on the part of the defense sometimes, it's a sign of discord or weakness and an opportunity for you to swoop in and take advantage of that.
Especially they can't stand it when you respond with calm and you don't rise to it, and it's not easy. But when they go try to insult you, they go try to threaten you, and you're like, well, if you'd like to follow up motion, just go right ahead. And you don't get upset. It drives them nuts because they're scared. So they're trying to scare you, and they're trying to intimidate you. And there's just nothing like that calm, quiet confidence. Like, well, go ahead. Well, that's well, I'm not going to pay you much money. Your worth isn't worth that much. Well, we'll go try it. I've won cases. I've lost cases. I've always survived. Let's go try it. And it drives them nuts.
Well, Sun Tzu says, violent language and driving forward as if to attack are signs that he will retreat.
Yep.
So, there's something to your intuition and to your trial strategies, because I think that's, true.
Well, to be fair, that's not intuition. That's not where I started. I started by fighting back.
Trial and error.
I started by going back even louder and more aggressive. And part of that was out of fear. And part of that is just, I grew up in a house where we yelled at each other. But I've learned and done a lot of work to get there that if I can just not let the other side get to me, I'm not going to give them the power over. I'm not going to let some jerkwad insurance adjuster or defense lawyer get to decide how I feel or how I react to something. I take that power away from them. And one thing that I've had to do, I don't know, it's more of a Buddhist concept. I don't know if Sun Tzu talks about it or not, because I think that's a different school. But it's not that you don't care about the result, but your work and your self-worth is detached from the result. So I think I'm a great trial lawyer, and I think I do great work. Does that mean I'm going to win every case? No. I have no control. And one thing I've learned is, like the case I have next week that I was supposed to try, I believe 100% it's their fault. I believe 100% my client didn't do anything wrong. I believe 100% my client was not hurt that bad, and he got hurt, and his life was ruined because of this. And I believe that with all my heart. But I also know I wasn't there. I didn't know him before this happened. So the only prayer I can have is that justice be done. I should be praying that I win, whether it's just or not.
Right.
And so, I know I can't control that. I can't control how a jury is going to take something. I can't control what rulings the judge is going to make. What I can control is my effort.
Enjoying the episode? Do you wish you had Trial Lawyer Nation on the go? Well, wish no more. The Trial Lawyer Nation app is available now exclusively on iOS devices. Access our entire podcast library, create a favorites list, search for old and new episodes, and much more. It truly is Trial Lawyer Nation at your fingertips. Download this free app now and enjoy the top legal podcast for plaintiff attorneys wherever you go.
Well, I do think, now having practiced law with you for a few years, I can tell you that has been such a liberating outlook to aspire to, because, I am obsessed with winning.
Yep.
And not losing. And when you obsess about not ever losing, taking risks is a lot harder. And when you lose, you take that loss a lot harder. So, having the opportunity to practice with you and looking at the outlook, you gave me a really good analogy early on. You said, look, did you ever play football, Sonia? And I said, no.
I got this from right at the beginning. I didn't think of myself.
He said, have you ever played football? And I said, no. I weigh 110 pounds. I've never played football. But you said, when you play football, even when you've tried your best and you worked your hardest and you've prepared your absolute best, you still lose sometimes. And so, that kind of approach and attitude to the practice of law was very liberating for me. And it makes the practice a lot more fun now. But I have concluded, Michael, that sometimes if you don't have the right mindset, that can also be a crutch, because it's easy to say, well, the judge is going to rule how the judge is going to rule, irrespective of what I do.
No, that's totally different. Yeah. That's not what I'm saying at all.
Because you still have to absolutely leave everything on the field, absolutely have to prepare. Only when you absolutely have prepared, you've done everything right, can you breathe and exhale and say, what's going to happen is going to happen.
What the mindset is it's my job. I got this from Sarah Lamont. My job is to fight. My job is to have the best possible trial I can give and do everything and our best possible settlement negotiation, best possible work, whatever it is. My job is to obsessively work hard and give it the best I can give. My job's not to control the outcome, although I want to win every case. Don't get me wrong. I want to get millions and millions of dollars on every single case. Doesn't happen, but that's what I would like. And I do. You see, I work hard, and I do care, and I care about my clients, and I do want to win. But I don't let detachment makes me. When you go in scared of losing, it affects you.
Yeah.
And so when I talk to Jerry, it's like, hey, that's your job. I trust you to do your job, but it's your job to decide whether I win or not. It's my job to sit here and give you the tools you need to do the right thing. And when you change your mindset there, and then have you been around me when I've lost a trial? I don't know if I've lost one since you've come in.
No, you haven't lost one in the last 3 years.
Yeah, well, it will happen sooner or later. I hope no time soon. I am not happy when I lose a trial. I'm not going to say I'm so zen that I don't second guess myself. I'm not happy, but I give it about 24 hours to more. And even when I won a trial, the last jury trial I won, and it was the biggest verdict I ever had, I wasn't happy. I thought it should have been more. I don't know. I thought it should have been more. I thought the guy's still freaking dead. It's great that we got a verdict. We said something really good for the widow, that, letting the world and the community say your husband had value, you have value was really important to her. But it felt very incomplete, I'll be honest. But because that's not, but I let it go. Whatever it is, I feel it, and you have to let yourself feel it. If you suppress it, it'll eat you up. But I feel it. I go home. I usually have a nice bottle of red wine. That's my thing. I don't drink it all by myself anymore, but I at least have a few glasses of it, and I let it go. And then it's gone. Bye.
Well, you and I had a conversation about letting things go a couple of years ago that really was just a couple minutes long, but it has changed my outlook on, winning and losing. And it was a big hearing that we had, and we hadn't yet gotten the ruling from the judge, but I was wringing my hands over the judge's impending decision. And you asked me, you said, Sonia, did you pull all the cases and do the best briefing you absolutely could? And I said, I pulled every single case that is possibly out there. I briefed it perfectly. And he said, if the judge makes the wrong decision, that's the judge's fault, not yours.
Yep.
And it was so liberating because I'd never really looked at the practice from that perspective. I'd always looked at it from my ability to make change or my ability to convince. But there are things that are the judge's responsibility and the jury's responsibility that I don't have control over. I can only control what I can do, and that's the best briefing that I can, or the best argument that I can, the best advocacy that I can.
And when we put responsibility on ourselves for things we cannot control, we're going to have a very unhealthy life.
It's true.
We're going to have a miserable life. We're going to either we're not going to take chances we should take. Because, sometimes the right thing to do is to go to trial when you don't have a guaranteed win, because the offer is not going to make a major change in your client's life. That you might win, you might lose, but the right thing for the client, what the client wants to do is to go in there and roll the dice. You need to be able to do that. And you don't want to be one of these people that's fearful, that's miserable, that's bitter, that's drinking the feelings away. You have to be able to let it go.
So we had talked about, coming into the recording today, talking about some of the mental health issues that come with stopping and starting trials. And so I don't know if we want to just keep talking or we want to do it on another day. But
I think let's get into that too. I think one of the hardest things for me, and again, the letting go, and it's so much work for me. That's one of the big goals in my life, is to try to perform at an excellent level, but then let go of the responsibility for the results. So like my job was to get ready for that trial next week. Now the court system decided it was not safe to have a trial next week. And I'm going to say, okay, I'm disappointed, but I respect that. I don't think the judge was doing that because they didn't want like us, or they don't want us to get justice. It's like, they don't think it's safe to go to trial. I respect you, Judge. I'll be even more ready next time. When I've like I said, by having tried about 100, I don't know, I've lost count, like 120, 125 cases. I've not only won more trials than most people have tried, I've lost more trials than most people have tried. And I've survived. And there's something liberating. The first time I put $100,000 into a case, I lost a trial. Within a week, it was very liberating because I was still in business. I didn't die. I didn't lose my house. I didn't lose my practice. People didn't stop sending me work because everyone said, man, you're a brave guy to try that case. That case really sucked. I don't know even why you took it.
Nobody boiled you up and ate you.
No one like put a dunce cap on me or called me a loser or, and so, and you live and you learn and you go on the next one. And when you're willing to go in there and risk it, then you're more likely to win. And then people are more likely to pay you and to not go down there because they're scared that they're going to lose that one.
I think a lot of it too, though, requires some level of discipline and commitment to keeping some kind of a healthy outlook on life, healthy lifestyle. I can't say that I work out or exercise at the level that I would like to, but, I'm trying to meditate now. So there is a component of peace in your universe that you kind of have to find if you're going to work in this practice of stopping and starting and not having control over whether you're going to go to trial when you've invested a ton of time, energy, and money in proceeding, only to have it pulled out from under you. I mean, it's disappointing. It's frustrating. It's, it's easy to get down. And so unless you have some kind of an outlet for yourself, I can imagine that it can beat you down. And you do have to be compassionate with yourself. Like on one hand, like I said, you can't let it eat you up, but you also, when you feel something, you have to let yourself feel it so that you can let it go. If you pretend it's not, the whole thing of the non-detachment, you can't pretend it's not there. It's like, I really want to go to trial next week, and it really sucks that I can't. And, we did all this work, and, we're going to have to redo a bunch of that. That stinks, I've got it. But at the same time, I can't do anything about it. So I feel it. Same for when I lose a case. I mean, I go in there, I second guess myself for a while. I feel really bad. I feel horrible for the client. But then I let it go. It's like, okay, I felt it. It's real. Now we let it go. It's like soldiers at war. I mean, you go in there and they kill your buddy next to you, and it's horrible. But you can't quit. You have to keep going forward. Or as athletes, I mean, you've got a whole season of games. You get absolutely destroyed one game. Well, you can't let it get you down. You got to go in there and try to win the next one. So it's a crazy profession that we've chosen. It can eat you up. It can also be incredibly joyful. I think, I really appreciate your approaches to creativity and finding ways to, pressure people, pressure the other side when we don't have our normal weapon of the trial to hit them over the head with. And, going from everything from, the most cutting edge, Nick Rowley, Sari de Lamotte, to going back, hundreds of years ago to Sun Tzu, whatever it takes. That's one of the things I enjoy about practicing with you is the creativity and open-mindedness. And I have actually admired the growth I've seen in you and, trying to struggle with not letting it eat you up and like, okay, you want to win every time, but realizing you're not going to win you don't win every single hearing on every single case, and that's okay. Right. And I think that's something that probably a lot of trial lawyers struggle with, perfectionism. Mm-hmm. And absolutely. I was talking to a neuropsychologist that we use as an expert in cases, and she was telling me that across the board, most all of the lawyers that hire her and that she works with have the same diagnosis of, hyper anxiety disorder, perfectionism, she's like, you guys are all the same, because y'all are all identical and all of you need to go to therapy. Well, we do. But, that struggle with being perfect, I think holds us down and holds us back. And it's the really great lawyers who can learn to excel after they can let go of that need to be perfect and the ability to fail. We had early on, you guys talked to me about working with somebody who had you guys practice trial strategies in front of other people where you were embarrassed or, not perfect situations, but you were embarrassed and you were put in awkward situations. And, the idea was horrifying to me. I mean, just the idea of being put on stage and being asked to do something that would make me look silly.
Yep.
Isn't something that I still think I'm ready to do. But,
yes, you are.
But, it just kind of highlights for me that there's still room for growth.
Yeah.
I've been practicing 25 years almost, and there's still room to learn and improve. And that's one of the things that I love about the practice of law now is that, we're constantly seeking to find areas to be better. And sometimes being better means working up the cases and representing our clients. But sometimes being better means, shoring up what we need to be successful. And that's your mental health and your outlook on your cases, your outlook on your practice, your business model. Everybody has a business model in their practice. And so that's a huge part of it.
Absolutely. And to all our listeners, I hope that you all are taking care of yourselves. It is still a crazy time. I thought things had gotten better in the summer, and then they seemed to go to hell again. And now maybe they're getting better again. Who knows? Take care of yourself. Be compassionate with yourself. Continue to be creative, to grow. I hope we've shared a little bit that can help you in your practice. If there's anything else that, where we could help you, anything you'd like answered, send us an email. We'd love to address it on a future episode. For those of you who do trucking and feel comfortable going to a public event, I'm the education chair for the Academy of Truck Accident Attorneys. We're having our annual symposium in Austin, Texas, on September 23rd to 25th. It will be available on video for those who can't attend, but it's not going to get live streamed because a lot of the COVID numbers were looking really good when we planned it. And then a lot of the different states for CLE credit are really strict on live streaming. There's no way we could have met all their requirements. But I would encourage anyone who feels safe to attend to attend. Like I said, but drop us a line if there's anything else you'd like us to address. I hope you all are all safe and thriving and happy. So look forward to having y'all tune again on the next episode of Trial Lawyer Nation.
Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you'd like to receive updates, insider information, and more from Trial Lawyer Nation, sign up for our mailing list at triallawyernation.com. You can also visit our episodes page on the website for show notes and direct links to any resources in this or any past episode. To help more attorneys find our podcast, please like, share, and subscribe to our podcast on any of our social media outlets. If you'd like access to exclusive, plaintiff lawyer-only content and live monthly discussions with me, send a request to join the Trial Lawyer Nation Insider Circle Facebook group. Thanks again for tuning in. I look forward to having you with us next time on Trial Lawyer Nation.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us. You can reach DeLisi Friday by calling 210-941-1301 or send an email to delisi@cowenlaw.com. That's DELISI@cowenlaw.com. She will coordinate a time for Michael Cowen to speak with you in person or by phone to discuss the case in detail and see where we can add value in a partnership. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our host, guest, and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.